Hello, everyone, and welcome back to yet another session on polity and constitution. I hope I'm audible as well as visible. Great, audible, and visible. Let's wait for others to join, and then we'll begin our discussion for the day. Okay, let's begin our discussion. We'll do a quick recap of what we studied in the previous class, and then we'll move forward. In the meantime, others can keep on joining. So, in the previous class, that is yesterday, we had taken up for discussion the topic CAA, that is the Citizenship Amendment Act 2019. We also discussed some terms like the OCI, the PIO. These have now been merged into an OCI card holder. Then other terms like NPR, NRC. Now, NPR is a list of what? NPR is a list of all the people living in the country, whereas NRC is a list of all the citizens. But as of now, NRC is only being conducted for one state, that is Assam. So we are done with the discussion on citizenship, a slightly low priority topic for the main examination and as well as the prelims examination. We have just had two questions in the last decade or so, 10 years. Then the union territories, the reasons why we have union territories, then the UTs for Pondicherry, UT for Jammu and Kashmir, as well as the UT for Delhi, NCTD, National Capital Territory of Delhi. Okay, so I hope there is no issue now. Audio, video, in case there is any issue, kindly refresh and you will be good to go. Okay, so NCTD, the National Capital Territory of Delhi, that's what we discussed yesterday in detail. And we discussed that right from the point of what is mentioned in the constitution with respect to Delhi. And then we moved on to understanding the issue between the LG and the CM, how the constitution clause 4 of this article brings about an issue between LG and the chief minister, and then this matter challenged in the high court initially, then supreme court, then the government bringing a change by amending the law, then a challenge again in Supreme Court with respect to the control over the officers in Delhi, and again an ordinance which is being brought by the government just a couple of months back. All this that we have covered yesterday. Then finally, Article 370. We discussed what exactly is Article 370, what is the temporary provision, how we saw yesterday how the center, the parliament, can make laws on the state list subjects, can make laws on the union list and the concurrent list subjects for Jammu and Kashmir. But then there's a small issue there. The issue is that the laws cannot be made on the topics without either the consultation, if the topic related to, say, things like defense, external affairs, or communication, or with the concurrence, approval of the state government if the topic relates to other topics, right? And as per clause 3 of Article 370, we can also modify Article 370. In fact, we can also make the provisions of Article 370 inoperative. But for that, the president has to issue an order called a presidential order, and this order can only be issued with the prior recommendation of the Constituent Assembly, a body framed, a body created to frame the Constitution. That's the purpose of a Constituent Assembly, okay, which is no longer there. And hence, the biggest impediment in the modification of Article 370, of course, the will of the politicians, but also the provision therein also created an impediment and obstacle in the modification of Article 370. That's all the ground we covered yesterday. Now, let's begin our discussion and see how the change was effected by the government with respect to the current situation. Okay, I hope now there is no issue with the audio as well as the video. Any issue, any concern? Okay, so for a lot of you, it is clear. This means for others where there is some problem, it would either or more likely to be at your end. So kindly refresh. Okay, just check your internet connection and stuff, and I think we'll be good to go. Okay, so beginning our discussion for today, starting with the first five questions. 45 seconds for each question. You know the deal. Let's begin marking the answer now. Okay, easy question with reference to the citizenship under the Constitution of India. Just a sec, guys. Okay, so coming to the first question, are we all okay now? Video, audio. Is the audio fine for those who had some problem earlier? Okay, great. So, the first question, with reference to the citizenship under the Constitution of India, consider the following statements. The Constitution provides for the categories of persons who became Indian citizens on the date of commencement of the Constitution. Of course, as we have seen earlier, that it all boils down to the date where we have commenced the Constitution. Which categories of people are Indian citizens? This is what is mentioned under Articles 5, 6, 7, and 8. Number two, The Constitution authorized the Parliament to make laws pertaining to acquisition and determination of citizenship is also correct, right? So, this is as per Article 11 that the laws will be made by the Parliament with respect to citizenship in future. So, both statements are correct. C, both 1 and 2 being the right answer. Okay. Moving on to the second question. How many statements are not correct? Which two statements do you find not correct? Because all of you marked 2 as the answer. Firstly, it was not correct and not the other way around. The Constitution authorizes the Parliament to increase or diminish the area. Yes or no? Of course, Article 3. So 1 is correct. Number 2, firstly, the President has to refer the respective bill to state legislature. Yes or no? The President has to refer the bill to the state legislature. It is one of the conditions. Or the Union territory. Sadly, this is not appropriate. This is not correct. The bill has to be referred only to the state legislature. The condition was not applicable to union territory. Refer to your slides and you will get the answer. Okay. So 2 is wrong. The president is not bound by the views of the state legislature. Of course, that is correct. The states have to give their opinion, which is not binding on the center. That's why we say that the parliament's power to reorganize the country are exclusive and plenary, unconditional powers, right? So 3 is also correct. How many are incorrect? Only 1 is incorrect, which is the second statement. So please don't be in a hurry. Also read correct and incorrect. Okay. Moving on to question number 3. Okay, easy question. The UTs of NCT of Delhi, Pondicherry, and Jammu and Kashmir have a provision for a legislative assembly among those legislatures which are created by the constitution itself rather than a law made by the parliament. So, of course, the NCT of Delhi, this has an assembly as per Article 239, capital A, right?
But for Jammu and Kashmir has the assembly, which is with respect to what? The law, the UT's Act of 63, as well as a Jammu and Kashmir Reorganization Act. So 2 is incorrect, 1 is correct. A, 1 only is the right answer. Are we clear on this? The UTs of Jammu and Kashmir. Now, coming to the fourth question. Okay, so the question says, what are those areas where the chairperson and the judge of High Court, Supreme Court have common aspects? So, appointment made by president on the recommendation of a collegium. This is meant for the Supreme Court and the High Court, but not for the tribunal chairperson, because the tribunal chairperson is to be appointed by the president on the advice of a search cum selection committee. But that search cum selection committee will not comprise of judges only, it also comprises of the secretaries, the IAS officers as well. So one is not common. No minimum age as qualification for appointment. This is also different. Yes, there is no minimum age for Supreme Court and High Court judges, but for the chairpersons of tribunals or members of tribunals, as per the recent amendment, there is a minimum age of how many years? 50 years. This is also not common. But yes, removal only on specific grounds mentioned by the law or the constitution. Misbehavior and incapacity. That's the ground on which both the judges of the courts and the chairperson of tribunal can be removed, respectively, the courts with respect to the constitution and the judges with respect to the Administrative Tribunals Act. Okay. So 3 is correct, which means C, 3 only is the right answer. And last question for the day. Okay, so a lot of you got this correct. Great. B is the right answer. It's a very simple, straightforward question. Uh, Statement number 1, that is A, is of course correct. Statement B is incorrect. D is correct. And these three are all part of Article 239, Clause 1, Clause 1, Clause 1, and this is 239, Clause 2. If you read Article 239, you will find that it mentions save as otherwise provided by the Parliament by law. So, administration of UTs can be changed by a law made by Parliament. It can be done. Then, every UT shall be administered by the President. Is administered by the President is also correct, right? Acting to such extent as he thinks fit through an administrator. So, the President appoints an administrator, and then the article continues saying, through an administrator to be appointed by him with such designation as he may specify. So, the designation of the administrator of UTs is specified by the President and not the Parliament. So this is wrong. And then the second clause talks about how a common governor can be there for a UT for a state, and the same person can be made the administrator of an adjoining UT as well. The example we saw was of the governor of Punjab, Banwari Lal Purohit, who is also given the additional charge of being the administrator of Chandigarh. Okay, so that's it. We are done with the 5 questions for the day. Coming back to Article 370. Uh, Let me just show the leaderboard. Kirtana, Janvi, Harish, Lucky, Sat, and Hilo. These 6 people getting all 5 correct, followed by others like Siddharat, Himanshu, Dhwani, Alina, Sumant, Bhavan, Ravisha, Naveen, Surya, Pratik, Abhinav, Ashwant, Priyanka, Dhara, Shali, etc. There could be others, but the leaderboard shows only the top 20 people. Okay, done. Let's move on to Article 370. I hope you remember yesterday we had discussed about Article 370 and I had told you what exactly was the current provision. Now comes the big question. There has been some change in Article 370, or else this would not have been in discussion, right? Something has happened. What has happened? And something has happened which the government is proudly boasting about, and other parties they are unhappy about. So this means there has been some kind of change effected by the government over Article 370. Now, before we begin this understanding of how the change was made, let me just tell you something, that in our constitution there are so many words that you find so many words that you find wherein the meaning of this word may not be clear. For example, I said while teaching Parliament that the financial year starts from April and ends on March. April to March, that's the financial year. But how do you know that the financial year starts from April and ends in March? Just because I told you. That's great. You should have full faith and trust in me. Amazing. I appreciate that. Or you may say, sir, it is written in Lakshmikant. But we also need to be sure of the definition being mentioned somewhere, that this is what is the financial year and not from January to December. So, where is that mentioned? So, there is an article 367 which reads interpretation. This means what? This means there are some words, not all the words, some words. If you have any confusion with respect to what is the meaning of the word, then what you can do is you can look into a law called General Clauses Act. This is a law of 1897. If you have any problem with respect to definition of certain words, you can always look into the General Clauses Act. For example, look at this. This is a small excerpt from the General Clauses Act. Look at how they define financial year. Financial year shall be the year commencing on the first day of April, or What is meant by government? Government shall include both the central government and the state government. What is immovable property? Immovable property shall include land, benefits to arise out of land, things attached to earth, or permanently fastened to anything attached to earth. That's called immovable property. So various definitions are mentioned under General Clauses Act. Okay. Now, before again we discuss how the change was made, one more point needs to be clarified. The point on what was the situation in Jammu and Kashmir in 2019. So, situation in J&K in 2019. First up, situation and the problem number one. In Jammu and Kashmir, there was precedent's rule because BJP and PDP had joined hands together to form the government. But then there's some issue or concern, there's a fallout, and the parties parted way. The coalition was demolished, and hence no party could form the government, no party could claim majority. President's rule was imposed on Jammu and Kashmir. Now, we'll be discussing this tomorrow, but for your understanding, if president's rule is imposed on any state, right, then under president's rule, what happens? Under president's rule, there is no state government, there is no state assembly. Governor acts for the government of the state, and the parliament replaces the state legislature. Are we clear on this? Under president's rule, it's a central government which controls the state. Under president's rule, it is a parliament which makes laws for the respective states. Clear on this, everybody? So this is the situation in Jammu and Kashmir in 2019, the month of July and August. That for government of the state, the governor is acting on behalf of the center, and for the state legislature, the parliament makes laws. Now, what happened? We know very well that to implement or to modify any kind of provision of Article 370, what is required? The requirement is that of Constituent Assembly. So, how was the change made? Very simple, very easy. The change was made by changing the definition under General Clauses Act. Definition of Constituent Assembly for Jammu and Kashmir changed. Simple. And what happened? Now, Constituent Assembly. Any reference to Constituent Assembly for Jammu and Kashmir would now mean State Legislative Assembly. State Legislative Assembly. And of course, the government of the state, whenever there is president's rule, would mean what? the governor. The definition which was changed was that Constituent Assembly for Jammu and Kashmir would mean the State Assembly of Jammu and Kashmir. This was a change made. Now, let's come here. If you are saying that the Constituent Assembly of Jammu and Kashmir actually means State Legislative Assembly, now during President's rule, what is State Legislative Assembly? It is nothing but the Parliament. Yes or no? And of course, we know very well that the government of the state is a reference to governor. Now, if this is the case, please tell me whose recommendation is required now? The recommendation of Parliament was required to modify Article 370. And of course, the Parliament gave the permission, and the President brought the order to modify the provisions of Article 370. Apart from it, the governor of the state also gave the recommendation to implement all the Indian articles on Jammu and Kashmir. The entire Indian constitution is now extended to Jammu and Kashmir. Remember, initially only two articles were applicable on Jammu and Kashmir, 1 and 370. To implement other articles of Indian Constitution in Jammu and Kashmir, the consent, the concurrence of the state government was required. But now the concurrence of governor is required. If the concurrence of governor is required, this would mean that central government's approval is required. Who is the governor acting on behalf of? A governor is acting on behalf of the president, which means the central government. So the constitution order was issued. This constitution application to Jammu and Kashmir order was issued, and all the provisions of the Indian constitution were applicable on Jammu and Kashmir. And also, with respect to the Parliament issuing modification, it was also done. The Parliament gave the recommendation that, sir, the President, please modify Article 370. So it remove. Revoke means to remove the powers of Article 370. So Article 370 still remains. Article exists. It has been modified. Are we clear? The powers of Article 370 have been removed. The article has been modified. Article has not been repealed. Let's be very clear. So what is the current situation of Article 370? This is Article 370 currently. Very simple. All provisions of this constitution, which constitution? Indian constitution. All the provisions of this constitution, as amended from time to time without any modifications or exceptions, shall apply to the state of Jammu and Kashmir. Notwithstanding, in spite of anything contrary contained in Article 152, 308, or any other article of the Indian Constitution, or any other provision of the Constitution of Jammu and Kashmir, or any law, any document, judgment, ordinance, order, bylaw, rule, regulation, notification, custom, usage, anything or everything, treaty, agreement, nothing will be applicable. Are you clear? Nothing is applicable. Only the entire Indian constitution is applicable on Jammu and Kashmir. Now, when you say that the entire Indian constitution is applicable on Jammu and Kashmir, this means Article 3 is also applicable. Yes or no? Article 3. What is Article 3? The Parliament's power to alter the boundaries, modify the boundary, increase the area, diminish the area, alter the names. So, since Article 3 was also applicable, the Parliament passed what we know as the Jammu and Kashmir Reorganization Act, reorganizing Jammu and Kashmir. Clear? This is what was done. So now Jammu and Kashmir was divided into two parts. Two districts of Leh and Kargil are now called UT of Ladakh, and the remaining districts are put under Jammu and Kashmir. Two UTs. I hope this point is clear. Now, also, just to clarify this point here, uh, when it comes to Jammu and Kashmir, that is, as far as J&K is concerned, the UT of J&K is concerned, it has the assembly, but the UT of Ladakh, it does not have any assembly. So, no assembly for the UT of Ladakh, but for Jammu and Kashmir, there will be a legislative assembly. So, it will have maximum 114 seats, out of which 24 seats will remain vacant. Why will 24 seats remain vacant? This part, the part, I'm drawing a straight line here, but this part, which has been occupied by Pakistan, that part will also have some members who will be some seats, representation from there also. Since this part is currently a part of or is under Pakistan's control. Hence, we have as a token representation said that some seats are there for this part also. One fine morning, if India gets back the entire Kashmir, we'll have elections here also, and we'll have MLAs in the Jammu and Kashmir Assembly from these areas also. Interesting, for the first time, we have reservation for seats, a reservation of seats for SCs and STs, and LG can nominate two women to the assembly. So this nomination of women to the assembly, this provision is only there for Jammu and Kashmir. It is not there for any other assembly, any other state or UT. Okay. Now, just like Delhi, where the Delhi Assembly cannot make laws on police, public order, and land, the Jammu and Kashmir Assembly also cannot make laws on police and public order. As far as Ladakh is concerned, no problem. Ladakh is just like any other UT, like say Chandigarh or Dadra, Nagar Haveli, Andaman, Nicobar, etc. So nothing special there. Brigadier Dr. B.D. Mishra was appointed the LG of Ladakh recently, and Manoj Kumar Sinha being the LG of UT of Jammu and Kashmir. Okay. Some of you are asking why land is allowed for Jammu and Kashmir. You should be asking a question, why land is not allowed in Delhi, not the other way around. Land has been kept out of the purview of Delhi because there are large portions of land in Delhi where you have the central government buildings also, right? All the embassies, parliament, the bungalows of central ministers, etc. That is why, to avoid any issue or concern, the land has been kept out of the control of the Delhi Assembly but is under the government center's control, right? Because large portions of Delhi are also used by center for delivery of governance. That's not the case for Jammu and Kashmir, right? That is why there is no need to keep a check on land centrally or control land as a topic of state list centrally. As far as the concurrent list is concerned, of course, the assembly can make laws on concurrent list as well, right? That's with respect to Jammu and Kashmir. The High Court of Jammu and Kashmir and Ladakh will be the common High Court for both the UTs. And now all the laws which are applicable in the country are now also applicable to Jammu and Kashmir and Ladakh. So earlier, simple example, IPC, the Indian Penal Code, was not applicable to Jammu and Kashmir. Jammu and Kashmir had its own penal code called RPC, Ranbir Penal Code. Now, of course, not Ranbir Penal Code was based on one former king of JNK, Ranbir Singh, not the actor Ranbir Singh, king of Jammu and Kashmir. Now that law was largely the same only with minor differences here and there, but it was called the RPC. Uh, Also, laws like Right to Education, Aadhaar Act, all such laws that you can think of, everything is now applicable to Jammu and Kashmir. That's it. We are done with Article 370. Okay. Now, coming back to this point, this change that was made, we should also know that this change is up for challenge in the court. So, petitions have been filed, various petitions have been filed, and this matter is also pending in the Supreme Court. Manohar Lal Sharma case of 2019, and next hearing will be on 2nd of August 2023. Let's see what Supreme Court has to say with respect to the changes made. The government has made all these changes, stating that we need to ensure what? Economic development of Jammu and Kashmir. Now, this change is a change of definition. This change is a change of definition. See, the idea behind this is very simple. You change the definitions of certain important words. Let me tell you, if today the parliament passes a law changing the definition, stating that the government mentioned anywhere in the constitution would always mean Narendra Modi, do you think this would be a nice change of definition? What do you say? Permanently, the government would always mean Rahul Gandhi. The government would always mean some. Of course, this change is wrong. How can you make such changes? Democracy goes away. The voters, electors, the electoral roll would mean the BJP party worker. So, some definitions should not be changed. Yes or no? What definition will not be changed? Who decides that? Because if we allow for definitions to be changed, then anything and everything can be changed. So, this is an example of doctrine of colorable legislation. What is this doctrine of colorable legislation? This doctrine of colorable legislation means what? It means what cannot be done directly can't be done indirectly. Or what is not allowed directly cannot be done Indirectly also, some people believe that under Article 370, Clause 3, the provision mentioned that the recommendation of the Constituent Assembly is required, that was done deliberately, right? That was done deliberately to ensure that in future no changes made to Article 370 until and unless the ground realities are restored. India takes over the entire Jammu and Kashmir. So the word Constituent Assembly was carefully used to prevent any modification, is the argument made by some people. Others say no, it is just an oversight, it was done by mistake. Now we don't know the mind of our makers, but this is what it is. Doctrine of colorable legislation. A simple explanation. Let us say you want to express your emotions to somebody and you type a message. Nice DP. That's how you start, right? Uselessly praising somebody. So you type nice DP and all this nonsense, very good answers, great answer writing. UPSC aspirant, we do this only. Now the person finally receives your call or replies to you saying, I should not receive a single phone call or text from this number. Mind you, behave yourself, or I'll report to the police. Okay. And you stop seeing the DP. So, what happens is somebody, you now who is gone all out and crazy to express your love, you go to the market, purchase a new SIM, and message again, hey, I'm back. You said I should not receive a single phone call or message from that number. This is a new number, different number. Is this allowed? Of course not. This is called colorable legislation. What is not allowed directly is also not allowed indirectly. Or you call your friend saying, come on, come here. You go and tell him or her how much I love the person. But you have been told, stay away. This means you will not try to approach the person indirectly also. So this is how this doctrine of colorable legislation works. Next time something of this sort happens to you, you can say doctrine of colorable legislation is being violated or is being brought into consideration here. Now, whether the change of definition should have been allowed directly or allowed or not, the Supreme Court will decide. There is no point in second guessing that. Once the court decides, we have to align our views with that of the court. And to be very frank, so much time has elapsed into this that nothing can be undone now. Firstly, if anybody here has this belief that things can be undone, uh, extremely unlikely. That may not be possible. Okay, so at best, Supreme Court can give some kind of scolding to the government, can say, government, very bad. You should have taken the people on board. But it's okay. That is by far the most likely possibility of the judgment, because so many steps have been taken now, right, with respect to governance structure there, that going back again 4 years back will be undoing lot of the present structure again. So it becomes a challenge. This is with respect to Article 370, and this is also with respect to the change made to Article 370. We cannot simply come here and discuss what Supreme Court may think or may not think. It's of no concern to us. That's it. Uh, just on this note, since we are discussing Article 370, you must have heard of this, something called Article 35 capital A. This article was not there in the Indian Constitution, but was only meant for Jammu and Kashmir. So, what is this Article 35A? Now, Article 35 is not something unique. Article 35A is a very old, I mean, the article may be new, but the concept is very old. The origin of this concept lies in a very old rule called state subject rule. 1927. So what happened was, back in the early 20th century, 19 or late 19th century, lot of Indians, us, we would enter Jammu and Kashmir and would try to settle there, purchase property, start business, much to the disliking of the locals there. So the elite people of Jammu and Kashmir, who were the Kashmiri Pandits and the Dogra elites, Dogra Rajputs, they were the elite people there. They did not appreciate us Indians moving into Jammu and Kashmir, settling there, purchasing land, starting business there. So they pressurized their king, Hari Singh, to make some kind of rule to prevent outsiders from settling or purchasing land in Jammu and Kashmir. So this provision of Article 35A has the origin in the Kashmiri Pandits and the Dogra Rajputs trying to push us out of Jammu and Kashmir, us Indians out of Jammu and Kashmir. So in 1950s, that state subject rule was made into a fundamental right for the people of Jammu and Kashmir. This is 35A. The JNK legislature can define group of people who will be called the permanent resident of the state. Okay. So there will be a category of people who will be called permanent residents of the state. This category of people will be given some special benefits, privileges, or rights. What kind of right? Complete reservation in the state government with respect to employment. All government jobs in Jammu and Kashmir will be reserved for state people only, that is, the permanent residents of the state only. Second, acquiring immovable property. Meaning what? Outsiders cannot purchase property in Jammu and Kashmir. Only those people who are permanent residents of Jammu and Kashmir could purchase property. Settling in the state, outsiders could not settle in the state, and right to government scholarships and any government scheme of the state government was reserved only for the permanent residents of Jammu and Kashmir. But Article 35A no longer applicable. This is also gone in August 2019, along with the change of the status. And permanent residents will be decided by the Jammu and Kashmir legislature. The people who have been living in Jammu and Kashmir before 1947, their descendants, etc., would be called permanent residents of the state. The legislature would decide on who will be called a permanent resident of Jammu and Kashmir. Okay, so and us being kept out was an original idea of Kashmiri Pandits and the Dogra elites, right? So sadly, things did not turn out well for them. Now they needed our support. But 70, 80 years back, they were the ones who were throwing us out. That outsiders, get lost, don't come here. Now, please help us, please. So, as the very famous song goes, what goes around comes back around. Anyway, coming to the provision 35A no longer exists now. So outsiders can go and purchase land. In fact, it is available. Please go and purchase land. So, the whole contention had always been that I want to purchase land in Jammu and Kashmir. Come on. Now it's there. Go and purchase it. Let's see how many people have the resources to purchase land in Jammu and Kashmir. So that's also there. But anyway, this ensures a sense of equality in the minds of people. This is the story of Jammu and Kashmir and the provision of Article 370. That's it. We are done with Article 370. I would not see any question being asked from this topic. Extremely unlikely. Because firstly, the matter is under sub judice. It's under court's discussion right now. Till the matter is sub judice, UPSC will not ask a question. Even after that, what question can they ask? They may ask you, not right now, but after a couple of years, that evaluate the benefits of the modification in the provisions of Article 370. So that we'll have to do based on some government data. Right now, when the matter is going on in the court, the government has submitted an affidavit stating the benefits that have come to the people of Jammu and Kashmir and Ladakh because of change of Article 370. So once the case starts, we also get to know what exactly is the content of the affidavit in full detail, and then we can also have what we can also have a thorough understanding of what benefits the government proclaims has been there for the people of Jammu and Kashmir. Okay. Now moving on to the administration of the scheduled and tribal areas, fifth and sixth schedule areas. So what is this scheduled area, right? What is a scheduled area? We'll be firstly discussing fifth schedule and then we'll move on to sixth schedule. Scheduled areas. Normally reference is given to the fifth schedule. The sixth schedule is referred to as the tribal areas. Firstly, what is a scheduled area? What is the definition of scheduled area? You'll be surprised to know that scheduled area is such an area which the president decides or calls an area to be a scheduled area. There is no other definition. The constitution under fifth schedule of the Indian constitution mentions this only. That area which the president calls a scheduled area will be called a scheduled area. And who can declare an area to be a scheduled area? Of course, the president. The president can also modify the boundary of a scheduled area, can increase the size of scheduled area, can decrease the size of scheduled area, and can also remove an area or add an area to a scheduled area category. So, what exactly is a scheduled area? Think of this. This is your state, any state. Let's say this is a state of Rajasthan or Madhya Pradesh or say Chhattisgarh or Gujarat, Odisha, Maharashtra, Himachal Pradesh, Madhya Pradesh, Telangana, uh, 10 states. This scheduled area is there in 10 different states. I would advise you to mug up the names of these states. It is extremely possible that UPSC will ask a question on this. Okay. Now, let's assume this is Rajasthan, entire state. Now, in this entire state, there would be certain small areas. Those small areas can be a district, can be a block, can be a village or group of villages. So these smaller areas, there is a small problem here. Small areas with small problem. The problem is that these areas have high tribal population with a very distinct way of life, which you may also say may not be a very modern way of life. These areas, which are tribal areas, have not seen economic, educational, or social advancement. These areas are called scheduled areas. Are you clear of the basic concept now of scheduled areas? So, not the entire state, but some parts of the state. Let's take the example of, say, Andhra Pradesh, like the areas of the east and west Godavari district, they are under scheduled areas. Or say Jharkhand, those areas which are some districts of under some areas under district of Latehar, Ranchi, etc. Same goes for Chhattisgarh. Bastar, Dantewada district. If you go to Himachal, the Lahaul Spiti area. Go to MP, the areas of Jhabua, Dindori, Mandla, those areas come under scheduled areas. Go to Rajasthan, Pratapgarh, Banswara. Go to Gujarat, some taluk in Tapi and Bharuch district, right? So various, go to Telangana, Adilabad, Mehbooabad, the rural areas of Warangal. So various small parts of these states come under scheduled areas. Clear? You don't need to know the names of those exact parts, but if anybody here belongs to any of these states, I would advise you to have ready some examples of certain districts in your state which come under scheduled areas. You can research for it online and get that information, because in the interview it can be asked. Clear? So if you are from, say, Himachal, they may ask you, in Himachal, is Himachal under Schedule 5 areas? You will say, yes, sir, it is under Schedule 5 areas. Of any example of any such area, and then you can give examples of certain districts. Clear? Scheduled areas, Article 244, Clause 1, the reference to scheduled areas in 10 states, some districts. What's the criteria? This is the criteria. There should be preponderance. What is preponderance? Meaning plenty of tribal people. What is that criteria? The criteria is more than 50% tribals. In that area, more than half the population should be tribals. Okay? So 50% or more. Or more. Number two, there is some kind of socio-economic backwardness in this area compared to neighboring areas. These areas have a marked economic disparity, underdeveloped nature. The concept only is based on the underdeveloped nature of these areas, and hence the center can decide on such areas being scheduled areas, schedule 5 areas. Now, they should be compact in size, they should be reasonable in size. You can't say the entire state is scheduled area, that's not possible. Okay, so some small part only can be under scheduled area. Thirdly, when you declare any area the scheduled area, it is very important that that area should be some kind of administrative unit. For example, it can be a district, it can be a block, it can be a gram or a village, group of villages largely. Single gram is unlikely. So it should be a viable administrative unit. You cannot simply say those two houses scheduled area, this colony scheduled area. No, it should be a proper viable administrative unit which will be declared to be a scheduled area. But the criteria is this: in any such district or a block, if you have uh, more than 50% scheduled tribes living, that area will be declared to be a scheduled area, or that area can be declared by the president to be scheduled area. See, this concept of scheduled area comes from a very old law. That law is called the Scheduled Districts Act 1874. Later on, the British Indian government also passed an order called Government Excluded and Partially Excluded Areas Order of 1936. So basically, there was this concept that certain areas should be excluded from the regular governance structure. Those areas which are inhabited predominantly by tribals were called excluded areas or partially excluded areas. That's the origin of scheduled areas. And why do we have scheduled areas? Why are we treating them differently? Because of the special efforts required for their social, educational, economic advancement we declare some areas to be scheduled areas so that the center can directly focus on those areas. Clear? Now, what will be the purpose? See, always remember to declare an area to be a scheduled area because it is the protection of tribals. So, of course, there are two very important elements. One is to prevent land alienation, meaning protecting the land of the tribals. Land alienation. Primary purpose is to protect the land rights of tribals. That is why outsiders are not allowed to purchase land in a scheduled area. A non tribal cannot purchase land in a scheduled area. Okay. Secondly, is this very important point that we want to also protect and preserve the distinct tribal culture and the tribal communities. Beyond that, there are other aspects also, that economic empowerment, economic empowerment. Then uh, we can say that we also want to provide a sense of social, political, and economic justice, providing social, economic, and political justice, providing, in short, good governance. Okay. So this is with respect to the reason, underlying reason for having a scheduled area. Okay. Now, what is the provision here? Number one, union government can issue center can issue binding directions to states with respect to administration of scheduled areas. So basically, the central government can declare areas to be scheduled areas. Now, and apart from it, it can also issue binding orders to the government on the delivery of services, etc., for those scheduled areas. So these areas are indirectly controlled by center. Okay. Now, governors of all these states which have scheduled areas every year or at any other time also, they have to submit a report. Governors have to submit annually a report on the administration of the scheduled areas. Clear? To the president. Also, governor is authorized to direct that any law of the parliament or the state legislature may not apply to a scheduled area. So, if the parliament makes a law, the center makes a law, the states make a law, those laws may or may not be applicable in scheduled area. Governors can modify the application. Look at the provisions given. Then, governor can also make regulations with respect to the business of money lending, business of money lending, and the allotment of land and transfer. So basically, in scheduled areas, land cannot be purchased by outsiders. We have to prevent what? Land alienation, taking away, alienating the land from these tribals. That is not allowed. Secondly, outsiders living a modern way of life, they will trap these innocent tribals in high debt by lending them money and all. So, money lending within a scheduled area is restricted. Tribals, if they want money, you please borrow from a an authorized financial institution called the bank. Now, governors can issue regulations, but when the governor makes regulations or rules, they require president's concurrence. Clear? President's concurrence or approval. So, this is with respect to the provision of money lending. So, the business of money lending, right? This can't be run in a scheduled area until and unless you are an authorized person or a financial institution. Okay. Now, in every state which has scheduled areas, every state, so 10 states, there will be a body set up called TAC, Tribal Advisory Council. Now, what is a scheduled area? An area, a small area which has very high tribal population, more than 50%. That is what is called a scheduled area, right? Now, there is a possibility. Think of this. Let's take this state. There are two states. In state 1, we find that there are some small pockets where you have very high tribal population. Okay. So, it can be called a scheduled area. But in state B, there is no such pocket, but we find that across the entire state the tribals are spread. We have high tribal population, 20-30% maybe, across the state, but in no specific place are they concentrated. But the problem is that if they are concentrated in a specific area, then scheduled area can be declared. But if the population is not concentrated and scattered all across the state, then you cannot declare a scheduled area, because one criteria is that it should have more than 50% tribals. That is why in such states also, this is state 1 and this is state 2. Here scheduled tribes are concentrated. Here scheduled tribes are scattered. So in these states also, there should be a tribal advisory council. TACs have to be set up in states having scheduled areas and also in states having scheduled tribes but no scheduled areas. Any example of such a state? Yes, there are a couple of examples. States like West Bengal, states like Tamil Nadu, Uttarakhand. As of now, just these three states: Tamil Nadu, West Bengal, and Uttarakhand. Just these three states are those states which do not have scheduled area but still have a TAC. Are we clear on this, everybody? Okay. Now, what is this TAC? Tribal Advisory Council. TAC consists of 20 members, and 3/4, that is 15 of these members at least, have to be representatives of scheduled tribes in the states. Representatives of scheduled tribes. Who are these people? Scheduled tribe MLAs. Scheduled tribe MLAs. Are we clear? So I hope you know that in the Legislative Assembly, there are some seats reserved for scheduled castes and scheduled tribes. Just like in the Lok Sabha, there is reservation of scheduled castes and scheduled tribes. Just like in the Rajya Sabha also. Yes or no? Tell me. How many seats are reserved for scheduled castes and scheduled tribes in Rajya Sabha? Okay. Thankfully, correct. Everybody is giving the right answer. I hope everything is okay. I am surprised. Yes, of course, there is no reservation whatsoever for SCs and STs in the Rajya Sabha. Great. Now, what is the task of TAC? TAC is, it's not some body which will perform some amazing tasks. It's basically a body to give advice. Advising the government, advice on welfare and the advancement of scheduled tribes. And just one point, when the governors make these regulations with respect to preventing money lending by businessmen there, or preventing the buy and sale of land to non-tribals, these regulations are made with the advice of the TSC. Here, the consultation with TSC. Okay, this is there. That is the task of TSC. Vivek, I think your question was addressed by the expert, right? I don't see the need for me to address that question, which was already addressed. Somebody says, please, sir, could areas having greater proportion of upper caste people be declared scheduled area? What do you think, guys? An area with a preponderance of upper caste people, can that be called a scheduled area? Of course not. There is a definition for the word. Then somebody will ask, sir, will area with a lot of Jains be called a scheduled area? Lot of Parsis, lot of Muslims? There is no point. There are hundreds of communities, but the scheduled area is based on preponderance of tribal population. Okay. Now, let me just ask you a small question here. Difficult times, revision time is always a difficult time. See, the scheduled areas have been comparatively isolated from the mainstream. Okay, comparatively isolated from the mainstream. Uh, when it comes to the provision of panchayats, that is the 73rd Amendment Act, the panchayat provisions were not applicable to Schedule 5, Schedule 6 areas, and states like Nagaland, etc. My question is, what step is required to be taken to also apply or implement the 73rd Amendment Act on Scheduled Area? Tell me, how can this be done? Parliament by law. Absolutely correct. The parliament will pass a law to extend the panchayat provisions to a schedule 5 or schedule 6 area. Or if we want to extend the panchayat provision to Nagaland, what step is required? Please tell me. What step is required? Some of you are mentioning the right answer, others are not revising at all, mentioning random things, assembly's permission, etc. President should pass a law. Don't write this ever, please. It's a crime. Presidents don't make laws. But anyway, for those innocent people who think revision is just a joke, uh, to implement The panchayat provisions in states like Nagaland, etc., the respective state legislature has to pass a proposal resolution with a special majority. The same majority required to amend the constitution is also required for that. So, for states like Nagaland, etc., state legislature, but for Schedule 5 and 6 areas, Parliament will do it. So, here Parliament by law. Okay. Now, back in 1994-95, there's a committee called Dilip Singh Bhuria Committee. So, this Dilip Singh Bhuria Committee uh, gave a report to protect the tribals from marginalization. We also need to implement the panchayat provisions to these areas so that the tribals can enjoy self rule, right? So the basis was the Dilip Singh Bhuria Committee report. Report of 1994-95. Based on the report, the parliament passed a law with a simple majority called PESA. PESA. Don't say PESA Act. PESA is okay. No problem. Panchayat extension to scheduled areas. PESA. If you want to talk about the law, then say PESA Act 1996. No problem. So PESA. This is the provision where the panchayat provisions are being extended to scheduled areas. This law was passed in 1996. What's the purpose? To extend the provisions of Part 9. What is Part 9? Part 9 is Panchayat of the constitution relating to the panchayats to scheduled area with certain modifications, providing, look at this, self rule for the bulk of tribal population, and to have village governance with participatory democracy, and to make Gram Sabha as a nucleus of all activities. Gram Sabha will be the center of all the activities. That is the purpose, giving self rule to the tribal population. Then, to evolve a suitable administrative framework, but we have to ensure that those administrative frameworks are consistent with the traditional practices of tribals. The special focus has to be on what? The social, the political, the cultural, of course, the economic aspects of tribal life. All these aspects of tribal life. This is what we have to focus on. Okay. So this is with respect to the scheduled tribes, their betterment in the scheduled areas. Then to safeguard and preserve the traditions and customs of tribal communities. To empower panchayats at appropriate level. What is panchayat at appropriate level? How many levels of panchayats do we have? Tell me. Three levels: the Gram Panchayat, the intermediate Panchayat, and the district Panchayat. Three levels of Panchayat. So, this is what is reference here to the appropriate level of Panchayat. Then, what are the provisions further? You know very well that with respect to the scheduled tribes and scheduled caste, their reservation, the reservation is based on their population. So in a scheduled area, up to 50% seats are reserved for scheduled tribes at all levels amongst members, amongst chairpersons, chairman at all levels, scheduled tribe. In a scheduled area, in a scheduled area, every chairperson, be it the Gram Panchayat, be it the intermediate Panchayat, be it the Zilla Parishad, every chairperson at every level in a scheduled area will be a scheduled tribe person only. Clear? Then, Gram Sabha has been given special powers in Schedule 5 areas. What special powers? Number one, ownership of minor forest produce, not major forest produce, because the forest produce major ones belong to the forest department. So, minor forest produce. What can be an example of minor forest produce? Things like bamboo shoot, things like, dry bark of trees, dry bark of trees like pipla, gumhar, etc. Right? The bark, the tree, that is a major forest produce. Timber, minor is these things. Or things like wild mushrooms, etc. Tree moss, all such things. Ownership of minor forest produce. Then enforcement of liquor prohibition. Gram Panchayat, block Panchayat, district Panchayat, they can enforce what? Liquor prohibition in their areas, banning liquor in their areas. Then control over local plans and resources. Example, managing water bodies, how to manage water bodies. So all these things have been left to the Gram Sabha. Okay. Preventing land alienation, land being sold or being transferred to non-tribals, it is not allowed. Okay. Then control over money lending. Again, the same old story that buying and selling of land. Gram Sabha can strictly make regulations. Nobody will buy or sell land to a non-tribal. Outsiders, non-tribals, you cannot start a money lending business in this village. Okay. Then managing village markets, matters of land acquisition, resettlement, all these things. Gram Sabha has been given a lot of powers. Clear? Then it is also a very important expectation that all the states which have scheduled areas, they should modify their panchayat laws in consonance, in accordance with the customary laws, giving or adding their social and religious practices also. Okay, so we have to give full support to the social and religious practices of the scheduled tribes, incorporate them as soon as possible. In fact, the provision said that within 1 year, the state governments have to modify their panchayat laws and add all the features, the custom traditions of the panchayats in their panchayat acts to allow for those things. Secondly, Gram Sabha or the Panchayat at appropriate level, either Gram Sabha or the Gram Panchayat or the intermediate Panchayat or the district Panchayat, any of these three, shall approve plans and programs for socio-economic development, right? And also identifying beneficiary. If the government launches a scheme in a scheduled 5 area, the scheme will only be applicable if the Gram Sabha approves or Gram Panchayat approves or Block Panchayat approves or Zilla Parishad approves. Without their approval, you can't even launch a scheme in these areas. Okay. Also, Sometimes, the Gram Sabha is also given the power to certify that uh, how much money was spent by panchayats. The Gram Sabha is asked, please give approval that the funds being spent by panchayats, is this correct or not? Then, with respect to mining projects, whether a public project or a private project, whenever any mining project is to be launched, mandatory clearance must be obtained after a proper hearing is conducted. So, a Gram Sabha meeting, hearing, what is this hearing? Gram Sabha meeting will be held, wherein the Gram Sabha will do what? Gram Sabha will hear about the project, look into what are the issues that may happen, what kind of land is required for the project, will they be removed from the land, will there be any kind of resettlement, or will there be any kind of compensation, what will be the environmental impact, will that impact them also. Only after a proper Gram Sabha meeting takes place, the particular company, the corporation goes for a proper what, a proper Gram Sabha meeting. Then the Gram Sabha approves, okay, we approve the project, and then only can the mining project start. Okay, special provision with respect to the PESA. Now, as of now, all the states have incorporated the PESA provisions in their Panchayati Raj Acts. I mean, there's no point in mentioning, but Rajasthan was the last state, and that Rajasthan also incorporated these in 1999 only. So every state has incorporated the PESA provisions in their Panchayat Acts to give space to tribal culture and custom. Now, when you make laws, you also have to make rules, or else how will you implement the laws properly? Right? So, the PESA Act, to implement it effectively, rules were required. 6 states had made rules till 2022. 6 out of 10 states. Last year, 2 states, Madhya Pradesh and Chhattisgarh. Chhattisgarh in August and MP in November. 2 in 2022. MP and Chhattisgarh. Total 8 states have made rules to fully and clearly comprehend the Panchayat PESA provisions. Okay. The remaining 2 states which have not made rules are Jharkhand and Odisha. So Jharkhand and Odisha are yet to make rules for the implementation of PESA provisions. When 6 states make rules, those 6 states made rules between 2009 to 2022. It is not required to know when those states made rules, right? And what are the other 6 states? We have in total 10 states. Jharkhand and Odisha have not made rules. Remaining 8 states have made rules, out of which MP and Chhattisgarh are mentioned here. You can simply use your reasoning abilities to find out the remaining 6 states. Okay. Upper statement says all states have done already. Garvit, this is with respect to modifying the law to add the provisions of PESA Act. This is the act. This is the law. When you make a law, you also have to make rules. Right from day one, we have been trying to discuss this only. What's the difference between law and rule? Anyway, it's okay. No problem. One fine morning, you will come to realize the difference. Okay. Vivek, sir, definition. Firstly, change the spelling of your definition. Definition of statute by law. Statute by law. Oh, statute actually means law. Statute. Now, uh, why have Jharkhand and Odisha not done it? I have no idea. Right? No idea. It was said that recently that Jharkhand and Odisha, both of them are trying to come up with the final rules, and it will be implemented at the earliest possible time. Okay. This is with respect to the current status of PESA. Clear? Now, coming to problems with PESA. What are the problems that are there with PESA? Problem number one, lack of exposure amongst members with respect to PESA. So people in these areas, they hardly have knowledge of PESA because of high levels of illiteracy, education levels very low, awareness is very low. So of course, lack of exposure amongst the members. Number one. The second point is law is very loosely worded. Now, why do I say law is loosely worded? Look at this provision. Let's read this only. For example, we have said that when it comes to implementing any government scheme or program, the government will take the permission of the panchayat at appropriate level or gram sabha, and then the provisions are going to be implemented or the scheme is going to be implemented. Now think of this. When the government, say central government or state government, wants to implement a scheme or a program in a certain area, do you think it is easy to get the permission of gram sabha? Have a meeting of thousands of people maybe, and then ask all of them, convince all of them? Or what you can do is call a person who you have sent in that area, who you have chosen after a very difficult examination of UPSC, the district collector. Call him saying, DC, you wanted posting in Delhi, deputation in Delhi. Okay, don't worry. I have launched a scheme, implement it. Get the approval. The district collector will call the Zilla Parishad members saying, hello, you guys want funds? Approve the scheme. The Zilla Parishad members approve the scheme. They can't refuse a district collector. When the DC calls the members of Panchayat, on their phone it says God calling. How dare they refuse the district collector's advice or their opinion? So, of course, the approval is done. In most cases, approval is obtained through appropriate levels only, never Gram Sabha. So, because the law says at an appropriate level, it is always assumed that the government will only use appropriate level. Approval by panchayat at appropriate level. Rarely Gram Sabha. Okay. Then one more thing is this forest department's excessive control over forest resources. See, in most states, the forest laws are yet to be modified. And because of that, uh, the forest department still claims ownership over the minor forest produce also. And the tribals are left out of any kind of control over the what? Minor forest produce as well. because forest laws yet to be modified to incorporate PESA. Then codification of customs has not been done. That is going to be a difficult task anyway, because what is codification of customs? Details. If a tribal group has some custom or culture, a distinct way of life, that should be given some statutory approval, right? Statutory approval. So codification of customs has not been done yet. It is yet to be done for most tribals. Then poor capacity building. What is capacity building? Training. Poor training of the panchayat functionaries here. One more thing. See, if that area in your state is an urban area, is a rural area, then for rural areas we have PESA. If a scheduled area is rural, then there is PESA. But tell me, if a scheduled area has some urban area, what is there? There is no MESA. MESA. Is there any MESA? No MESA. Simple. So there is nothing called MESA. So if I know very well, that if an area which is a rural area comes under schedule 5 area, I have to implement the PESA provisions, modify the state law, look into their tribal life, collect data on their customs, culture, etc., their marriage, their divorce, their inheritance, succession, all these things, and modify the laws accordingly. Effort is required. But if the governor issues a notification that this area is now no longer a rural area, this is a transitional area. So, all those areas which are transitional areas, transitioning from rural to urban, they are called Nagar Panchayat. Remember, Nagar Panchayat is a part of urban local governance, municipality. Yes or no? Nagar Panchayats, municipality or municipal council or municipal corporation. So governments very smartly convert that into Nagar Panchayat to escape any kind of responsibility of PESA, right? Then, very important, we have just seen here that, with respect to mining projects, when mining projects are incorporated, Gram Sabha meeting has to be held. Really? Gram Sabha meeting? Do you think Gram Sabha meetings take place? On the ground, nothing like this happens. What will happen is the DM will call the Zilla Parishad member. Hello, guys, get the approval of Gram Sabha. So the register is taken out. On that, minutes of meeting are recorded. Signs of 100 people are randomly taken, and it is assumed Gram Sabha meeting was over. And see, 100 people have approved that yes, we were sitting in the meeting and we have decided to give approval to the project. That's it. You will be doing all these things in future because it is required. So the Gram Sabha meetings are largely a farce. So don't think that the public hearings take place on a large scale. Gram Sabha meetings take, it does not take place. That is why there is actually a suggestion here that video recording of meetings should be done, and those recordings should be made available on any public domain to people. Lastly, the provision with respect to MOUs. What are MOUs? Memorandum of Understanding. Memorandum of Understanding. So, in your current affairs books, you see monthly magazines that this minister has gone to some foreign country and has signed 16 MOUs on agriculture, on say environment, on water conservation, all these things. So basically, the idea is that I have in my country obtained some land after clearances and approvals, have a project in mind. I go to a foreign country, tell them this is the project. You bring your money or technical expertise. We are giving you resources. Start a project here. That's the right way. Okay. But what happens is the government will go out, ministers, sign approvals saying, "Arey sir, come to our country, no problem. No problem. You come to our country. We have everything available." Just like, a father would go and meet some person and say, "Sir, I have come for my son or daughter's marriage. Don't worry. He or she will agree only. You come to our house, no problem." Without consulting the son or daughter, you have gone ahead and signed a deal. Same thing happens. That is why, and now when the minister comes back, calls the DM, says, "Come on, DM, approve it, get approvals." By 2 months, within 2 months, you have to get all the approvals. The party is coming, the FDI is coming, the money is coming, the business is coming. Get approvals. And how do you get approvals? Forcible, or keeping the tribals in dark. And the project, the party comes, the MNC comes, the project starts. Tribals are surprised. NGOs come, they say this is wrong. Cases filed in Supreme Court. Supreme Court says stay order. Why are stay orders issued? Because somebody is filing a case. Why are cases being filed? Because you have not taken tribals on board. Use of government machinery to enforce MOUs without appropriate PESA implementation. MOU, Memorandum of Understanding. Are we clear on this? This is why we have lot of problems, because the government has shown no interest whatsoever when it comes to enforcing truly the PESA provisions, because it is time consuming, right? This government has no interest in discussing bills in the parliament. Do you think they would have the patience to let the Gram Sabha approve the projects in its own sweet time? Of course not. That is why, there's a very interesting play of words, that government, government and tribals. What do tribals want? Tribals want PESA to be implemented properly. Government wants PESA, money. And because the government is enforcing MOU, government has become MOU Wadi. Of understanding. Government has become MOU Wadi, which is forcing the tribals to become Maowadi. And this tribal provision, that, this PESA provisions, which looks to be a harbinger of hope and promise for all the tribals, making them masters of their own destiny. It has largely not happened in the ground level. And, the tribals are losing this battle of the three J's: jungle, jal, and zameen, on a daily basis. Anyway, that is all as far as our problems with PESA are concerned. We are done with our discussion on the Schedule 5 areas. Let's take a break, and after break, we'll take up for discussion the schedule. 6 areas come back at 805. No confusion today. Break till 805. Break, please. Okay, let's continue. Megha, what is MOU-wadi, Maowadi? Ignore this. This is just meant for those who understood the pun behind it. It's okay. Ignore it. It is of no relevance. You can't write this in the examination. Forget it. Forget it. My bad. Ignore it. Shivani, let's come to Schedule 6 first and then I'll discuss that point. Uh, Ashwant. Okay, Ashwant, I saw your name in the leaderboard today. So, Amandeep, yes, we should. In the recent times, this topic has become very important. So, yes. Nitin, when was PESA introduced? Any committee recommended for it? So, I think Nitin was not really available for the class because this was mentioned here. PESA was introduced in 1996 on the basis of this committee's recommendation. Okay, no problem. Has to Bibin, he has to vacate the office. Okay, once he becomes a president. Nirbhay, is PESA implemented? Of course, PESA has been implemented. Sachin, no, not for Schedule 5 areas. Tribal advisory councils are meant for advising the governor with respect to the welfare of tribals for the scheduled areas, not the entire state. Why Schedule 5 and Schedule 6 are different? How will you know this without knowing Schedule 6? At least wait for Schedule 6 to start. Okay. Priyanka, you please refer to Panchayat. There is a slide called Part 9 not applicable to certain parts. Article 243, capital M. You will find the answer for your question there. Now, what more spoon feeding? Gauri, just wait. We'll discuss two previous year questions that were asked in the prelims from this topic. Anjali, most states have two rounds of elections. Largely, what happens is that for most states, the elections to the sarpanch and the gram panchayat take place separately, and for elections to the uh, block panchayat, that is intermediate, and the district panchayat take place separately. Money, if the particular village is of 100% of ST people, that's a 50% or more is the criteria. If an examination says that people who score above 50% can sit for the examination, are eligible, you have scored 100% marks. Are you eligible, Money? Tell me. Priyadarshini, sir, can a governor of a state issue ordinance when the assembly is dissolved or suspended? Yes, of course. Now, coming to the what? Schedule 6 areas. Schedule 6 areas are slightly different from Schedule 5 areas. Now, you may say, sir, why are we treating these areas differently? The focus is tribals only. Yes, of course. Scheduled 6 areas or tribal areas under Article 244, Clause 2, sixth schedule of the Indian Constitution. Here, we are treating these areas differently because of certain reasons. Because here, there is the issue of ethnicity. Here, we need the protection of tribal culture. A distinct culture is there. Okay. Also, we have to prevent insurgency, separatism. Are we clear? These areas do not have the same concerns as the other tribal areas. So, let me tell you firstly that if you look at the northeastern states, preponderance of scheduled tribes. Please don't think that these or don't have this belief or don't have this visual image that the tribals of northeast are like the tribals you find in the remote areas of MP or Chhattisgarh, etc. No, these tribals are highly modern, very high literacy levels, highly westernized. Look at how they dress in a very stylish manner, right? They're educated people. Okay, they're fully aware people. So the problem of lack of education is not a concern here. Are you clear? So that is never a concern here. The concern is the pockets of insurgencies that happen in these areas, which have largely come down now. But yes, that is why we were treating these areas differently. Clear? And largely, these areas never being the part of the traditional mainstream, we also needed to give them lot of autonomy and space within the larger fold of Bharat. That is why treating them separately. Clear? So there was a committee called Gopinath Bordoloi subcommittee. This Gopinath Bordoloi committee gave the recommendation on which the scheduled 6 areas were brought into picture. Now, again, what's the purpose here? Firstly, the purpose. Same old story. Preserving and protecting the tribal culture, protecting the land rights. So, two things are common here also: protecting the land rights of the people of these areas. Number two, preserve and protect the distinct culture. Then also ensuring democratic devolution of power. Democratic devolution of powers. And lastly, speedy transfer of funds. Speedy transfer of funds. Four reasons why we have scheduled 6 areas. Now, what are these scheduled 6 areas? Schedule 6 areas are just like Schedule 5 areas, small districts, right, in 4 northeastern states of Meghalaya, Mizoram, Tripura, and Assam. Look at this diagram, you'll understand it. So, this is the northeastern part of the country. Let's use yellow. So, this area that you see till Dima Hasao, Assam. Okay, so these three are parts of Assam. This is Tripura. So you can see that this is the schedule 6 area in Tripura. This is Meghalaya, entire state of Meghalaya. You can see this is the schedule 6 area of Meghalaya. Almost the entire state of Meghalaya is covered under schedule 6 areas. Then this state is Mizoram, and you will find that again some small parts of Mizoram, Chakma, Lai, and Mara. What is ADC? I'll discuss later on. Don't worry. Chakma, Lai, and Mara districts are under the Schedule 6 areas. Clear? Uh, then this state is Manipur. In news recently, here we have Nagaland, then Arunachal, Assam, the seven sister states. Okay. So, and this is Assam. In Assam, you have Bodoland as a Schedule 6 area, then Karbi Anglong as a Schedule 6 area, and Dima Hasao as a Schedule 6 area. I hope this diagram is clear for everybody, and now you have a clear understanding. Okay, only these. Please don't ask other things. Sir, is that area Schedule 6 area? Is that? It is not. If it was there, I would mention it. Why would I hide this information from you? What would I get by hiding this information? Gorkhaland, not a part of Schedule 6 areas. Southern Hills, not a part of Schedule 6 areas. So, these areas are not a part of Schedule 6, right? So, don't assume things on your own, is my request. Clear, everybody? Okay. What is ADC? We'll discuss it shortly, so have patience. Now, for all those enthusiastic people who may say that why is Ladakh not there? Now, let me clarify here only. There is a demand right now for Ladakh. Ladakh has 97% tribal population. How much? 97%. As of now, as of now, the Ministry of Home Affairs, MHA, by now I believe you know what is MHA, Ministry of Home Affairs. MHA has set up a committee. This committee's task is what? Is to look into protecting the land and employment of the people of Ladakh. Okay. So this committee is going to look into whether the demand of Ladakh can be incorporated under Schedule 6 or not. Clear? Uh, Ilyas, sir, why we have two schedules if we... I just explained it. Okay. So, once again, for the late joinees or the ones who were sleeping, I'm not sure what you were doing. Anyway, ignore that. So, we have Schedule 6 areas. We treat them separately because the problem here is not just a tribal population with a distinct culture which requires protection. That's there. The issue here which we are dealing with was also separatism and insurgency. More on this when you study your internal security module. Okay. Apart from this, one important element was also that these areas were never largely seen as a part of the larger mainstream of Bharat. So we have to also slowly integrate them into bring them in the mainstream. Okay. So that also requires a special treatment. That is why you will find out right now that even though these are tribal areas only, the treatment is completely different. In Schedule 6 areas, you have lot of autonomy being given to the these areas. That is why I have mentioned here democratic devolution of powers in a democratic fashion, meaning giving devolving powers to people. You'll be surprised to know that in the Schedule 6 areas, right, in these districts that the diagram we saw, they have powers which are legislative powers, they have powers which are executive powers, they have powers which are judicial powers, they have financial powers, which is not available to Schedule 5 areas. Clear? So, Schedule 6 areas, 10 districts, 4 different states. Please remember the names of all these 4 states. Now, what is the provision? The provision is that in all these areas, schedule 6 areas, we will identify what autonomous districts, and then will create something called an ADC, also called DC. Autonomous district council will be created for each district. So let us say Garo Hills, Chakma. For Chakma, you have what? Look at this. Chakma Autonomous District Council. For Garo, Garo Hills Autonomous District Council. Khasi Hills, Khasi Hills Autonomous District Council. Okay. For Tripura, Tripura Areas Autonomous District Council. So TA stands for Tripura Tribal Areas. ADC is Autonomous District Council. Now let's look at Mizoram. In these areas, you have Chakma ADC, Lai ADC, Mara ADC. What about other parts? Other parts. In other parts of Mizoram, we may have an RC also. A regional council can be set up in other areas with a substantial tribal population, but so far we have ADCs. So we'll focus on ADCs only, autonomous district councils. Now, each DC or each ADC, DC, ADC is the same thing. The constitution uses DC, so we are using DC, but it is commonly known as ADC, Autonomous District Council. Each district council will consist of not more than how many members? Not more than 30 members. Out of these 30 members, 4 are nominated, rest of them are elected. 26 are elected, 4 are nominated. And in with respect to their election, the governor will make rules on how these people will be elected. The election procedure, governor makes rules. Okay, and the nomination also comes through the governor's rules only. What is the procedure? Governor makes rules. Clear? All these things are always decided by the governors only. I think we had seen uh, a few moments back about the TAC, the Tribal Advisory Council. There also the exact same provision that the TAC members are uh, functioning with respect to the rules which are regulated by the governor, because in these areas it is the governors who perform lot of functions, and hence the special powers given to our governors. This is something that you have to understand for the schedule 5 and schedule 6 areas. And when we say governors, we mean to say what? The central government, because eventually the central government is the one which controls the governors. Okay. A small point is this exception. Exception is Bodoland District Council, but Bodoland District Council is called Bodoland Territorial Council. This Bodoland Territorial Council has 46 members, not 30, but other ADCs have 30 members. Now in Bodoland also you have 46 members, 40 are elected, 6 are nominated. Out of these 6, 2 have to be women. Out of these 40 who are elected, 30 should be tribals, 5 should be non-tribals, 5 seats are open. All these things are of no concern to us. This is sufficient information. Okay. Now, laws made by DCs and RCs require governor's consent, which means what? DCs and RCs can make laws also. Now, over those matters on which ADC, that is the Autonomous District Council, can make laws, state laws shall not extend unless the ADC approves. So, if something has been given to the ADC, the power, the state laws will not extend until and unless the ADC allows. Clear? I hope everybody is clear now with this map and diagram also. We'll move forward and we'll continue our discussion further on the ADCs. Now, first up, legislative powers. Legislative law-making power has been given to the DCs. Okay. So, same old story. Allotment, occupation, and use of land. Land alienation will not happen in these areas. One more thing. If anybody here has this kind of confusion, that this kind of land alienation, can it not be done by government? So government can occupy land. Are we clear? I'm repeating this. I won't repeat this ever again if you ask me a question also, because I'm seeing some of you asking questions from the point I'm just explaining. So you have to focus here, right? Government of India and government of states, they can acquire land compulsorily for a public purpose. No law can prevent the government from acquiring land. Are you clear? That's there. And for all those people who are still did not understand, I'll explain again DC and RC. Firstly, DCs are also called ADCs, Autonomous District Councils. RC is not called ARC. Don't create words on your own, please. Okay. Now, take the example of Mizoram. Think of this as Mizoram. Mizoram. In Mizoram, you can observe that the lower part of Mizoram, you can see here, has 3 different districts. These districts are called autonomous districts. This is the Chakma ADC, this is the Lai ADC, this is the Mara ADC. Yes or no? Are we clear, everybody? And those who do not understand, now is it okay? District councils. In these autonomous districts, people here would elect and choose members who will be a part of a group called district council, also called autonomous district council. Clear? Okay. Now I would want those people who are asking question to say yes, whether they have understood or not. Others, I have no interest. They have understood already. Silence. I feel somebody who asks a question and goes away somewhere, enjoying life. Strange group. Anyway, so now this is the entire state of Mizoram. In certain areas which have very high tribal population, mixed tribal populations of various groups, there, of course, we have district autonomous districts. In other areas also, tribal communities will exist. Yes or no? May not be 50%, maybe 30% only, maybe 45% only. They may exist scattered all across the state. In these areas, we can have RC, Regional Council. Are we clear now? Everybody, difference between RC and DC. I'm yet to get the yes from the person who asked a question. Maybe he has gone back to sleep. It's okay. So, moving on now. I hope you understood the DCs and RCs. So, always remember going back to the original idea, because we have to merge these people also in the mainstream, right? So that they don't feel excluded. Yet these people, educated people, high literacy rates, a modern way of life, right? So we cannot treat them in the same fashion as we are treating the tribals of other areas. We know that these people are educated, so we have to also devolve lot of powers to them to make them feel that what? To make them feel that they are also a part of India, yet we are fully uh, in this belief that we will give you space and freedom to practice your own culture, protect your own customs, and have your own way of life. Govern yourself. In the larger fold of Bharat, be yourself. Okay? Now, first up, legislative powers, allotment, occupation, use of land, management of forests. Of course, when I say forest, don't say forest reserves. Forest reserves will not be managed by the ADCs, except the reserves. They are managed by the state government forest department. Use of canals, water courses, water bodies in those ADCs. Regulation of the practice of shifting cultivation, jhum or jham, I don't know what you call. So the regulation of what? Jhum or the shifting cultivation. Establishment of village and town committees. Establishment of village and town committees. Then matters relating to village and town administration. What kind of matters on which they can make laws? They can make laws on police matters. They can make laws on sanitation. They can make laws on health, etc. Are you able to understand the importance here? They can make laws on policing matters in the ADC, the respective ADC. Look at the level of autonomy being given to these areas. Then appointment and succession of chief and headmen of tribes. So all these tribal communities have their own tribal way of life, where you have a tribal chief, headman, etc. So they follow their own regulations. They make their own laws to of a procedure to appoint who will become the next head of the tribe, chief of the tribe, etc. Okay. Then all aspects of personal laws. What are personal laws? On personal matters like marriage, like inheritance, etc., divorce. So, these ADCs have their own personal laws. Uniform Civil Code. How can we apply Uniform Civil Code? ADCs have their own laws. Then, executive powers. After you have given them powers to make laws, give them also the power to implement laws. So they can establish, construct, and manage. Of course, this will only happen with the prior approval of governor. Establish, construct, and manage primary schools, dispensaries, markets, road and water transport, cattle ponds, fisheries, ferries, etc. Okay. Then, management of agriculture, animal husbandry, community projects, social welfare, cooperative societies, village planning, all sorts of things. They have the power to execute their laws that they make. Then, judicial powers. Let me also clarify that uh, in these district councils, these autonomous district areas, they have their own separate court system. So you have at the lower level something called a village council. The decisions of village council are then challenged where? They are challenged in the, sorry, village council challenged in the district council. And then District councils can be appealed. This is appeal in the high courts. So this is the two-tier court setup that you have. Separate courts also. Now, one limitation is that these courts only resolve tribal disputes. Settlement of disputes among STs, scheduled tribes only. Non-tribals cannot go and file a case here because it is comprising of the members of tribal committees only. There could be biasness. That's also a reason, very valid reason as to why the settlement of disputes should be amongst tribals only. Okay. Then financial powers. What kind of powers? Financial powers. Powers of taxation. So they have the power to levy. Levy means impose and also collect taxes. Taxes on land revenue, taxes on animals, vehicles, entertainment, amusement parks, amusement parks, etc. Okay. Uh, Now, for what? Why are they being given the power to collect taxes? For the maintenance of schools, maintenance of dispensaries, maintenance of roads, etc. Then we have something called CFI. Yes, or the Consolidated Fund of India. We have CFS also, the Consolidated Fund of the State. And then at the panchayat and municipality level, if the state legislature allows by law, then a fund can be created for the panchayats and municipalities also. That is under Article 243F. Sorry, 243H. Now, similarly, there can be a creation of a district fund for the DCs and a regional fund for the RCs. It can also be created. So, a fund can be created wherein all the money comes into the district fund or the regional fund. Clear? So this is with respect to the structure of these schedule 6 areas. Now, very important. The central laws or the state laws, they may not apply, or if they apply, they will apply with modifications, right? In the state of Assam, the ADCs of Assam, the governor decides whether the central or state laws will apply or will apply with modifications. In the state of Meghalaya, the president decides. In the state of Tripura and Mizoram, governor decides for state laws and the president decides for central laws. So please make sure you remember these points. They can be a possible prelims based question on this slide itself. Okay. Applicability of central and state laws. Now, just a small point. See, governor can appoint a commission to inquire into the report on, inquire into and report on the administration of DCs and RCs. Governors have the power to appoint a commission, but that's separate. One very important point, please note, very important. We have seen that so many powers have been devolved to the ADCs. I mean, look at the powers, and they have powers to make laws, implement laws, financial power, separate court system. So, what if they make some law? They make some law, pass some resolution, make some rule regulation, which violates, endangers the safety of India, which is harmful to public order. If that is the case, the governor can cancel those laws also. So please, there is a check. Governors can cancel, annul, or suspend laws, rules made by ADCs if they are likely to endanger, they are likely to endanger the security of the country, the safety of India. Also, they are, uh, if they are prejudicial, harmful to public order. So this is with respect to the governor's power. So ultimately, governor is the boss, center is the boss. So as I said, that you have full powers of enjoyment. Nobody is stopping you. But if you try to make a law which in any way creates some kind of animosity, if you are trying to make a law saying we will now be a separate country only, let's say some ADC passes a law saying we are now a separate country, don't interact with us, those laws will be cancelled, right? So any law which violates the safety of the country, which is harmful to public order, those kind of laws will be cancelled. If you pass a law which looks into, let's say, creating some kind of tribal dispute, because see, that's one issue actually. In these areas you will find there is preponderance of tribal population, too many tribal people living in these areas, and not one common tribe, multiple tribes running into dozens and dozens of tribes. Every tribal group has its own way of life, a distinct custom, so you have to also take into mind those customs, right? So let us say one such tribal group has a dominance in the ADC because it is large number. So we should not let this happen, that that tribal community starts making laws because it controls ADCs, starts making laws which are harmful to other tribal groups, because it will only create animosity and raise an issue of tribal conflict, such things. Okay. Prejudicial, I said this 5 6 times, harmful. Okay. What is the issue of Manipur? Manipur is the issue we'll discuss in internal security. It is not a point we discussed here. See, basically, Manipur, the Metis versus the Kukis. Originally, Metis were Khuman, Luwang, Moirang, and Metis. Later on, the Metis absorbed all these four tribes, right? Uh, this data is from this book called Breeding Manipur. Anyway, the Metis have roughly 64 to 65% population, but they are concentrated in the Imphal Valley only, in around 10% land. But because of huge population, they also command majority in the assembly, 40 out of 60 seats. Whereas the Kukis, the Chin tribes, Nagas and Kukis, combine together to form around 35% population and 90% land. So the Nagas and Kukis largely are spread all across Manipur, right? But with lesser population. Whereas the Metis are concentrated in a very small area of Imphal Valley. Now, High Court's order had come that Metis also should be included under scheduled tribe category, because when you include somebody under scheduled tribe, they get the benefit of reservation and other aspects. So denying Metis the right to be included under scheduled tribes violates Article 14 and Article 21. And the High Court asked the state government to send recommendation to the center within 4 months. The problem is that we'll discuss this later on under Article 16, that scheduled tribes and scheduled castes, the list can only be prepared by the center. Parliament can modify the list. If you want to add any person's name in a scheduled caste category or scheduled tribe category, the state can only make recommendation. The parliament approves it. So the High Court has asked the state government to forward the recommendation to the center to also add Metis in the scheduled tribe category. And you know very well, whenever the reservation matrix is modified, new groups are added, existing groups face some threat from the new groups. And when you add a new group, it has to be based on some data, some fact, etc. So those are concerns and issues which are best left for the newspapers to discuss, not for us to worry about. Anyway, you'll be discussing this in your IR classes. Vivek, may I ask, sir, is polygamy practice? So your focus is on polygamy and polyandry. I think this is what UCC is all about, right? Polygamy. Why is somebody marrying 4 times? I'm not getting the opportunity. UCC is way beyond that. Maybe, I'm not sure. If some tribal community is practicing polygamy, I am not sure about it. So if it is practicing, we'll have to look into it. But I don't know. So, and for others also, I'll tell you, this should not be in your mind that, oh, somebody is getting the benefit of marrying 4 times. I also want that same benefit. Please. Okay. This shows that this is a classic example of single life. Single life people have no understanding of how complicated things can become. You feel it's all fun on the other side of things. It is not fun. No, I don't have personal experience of fun or no fun. I'm just giving a public opinion in general, right? Okay. Anyway, coming back here. So now coming to the issues. What are the issues? Very generic and very basic issues. See, one thing we discussed under Schedule 5 areas was that when it comes to Schedule 5 areas, it has largely been unsuccessful, frankly. I mean, the condition of tribals has not improved. I'll not quote a movie called Kantara to showcase that. But the point is that the lives of these tribals has remained the same largely, and they are facing a lot of problems because tribals have owned land since generations. They can't identify, they have no property, right? No papers. So infringement by the government, curbing their basic rights, curbing their way of life is happening. But schedule 6 areas, the schedule 6 areas have largely brought lot of success. They have helped in bringing down insurgency. They have given a measure of self rule to tribal communities. It has ensured the mainstreaming of northeastern parts of the country also, right? So schedule 6 has been way more successful than schedule 5 areas. Now, what are the issues? Number 1, codification of customary laws. See, this is actually a problem. I mean, it has to be a problem. There are so many tribal communities following different customs. We cannot simply make laws of all those customs. It is a difficult task and a challenge in itself. So, codification of customary laws is also a problem in lot of these uh, areas. We find that, for example, Tripura. Tripura is a state with which is a highly heterogeneous group, various tribal communities. Not all tribal communities' customs can be codified. It becomes a challenge. Example, Tripura, where you have multiple tribal communities. I mean, imagine in India there are hardly, two major religions, Hinduism and Islam. Sanatana Islam. Apart from it, there are other religions are very small in number, less than 3% individually also. So we are not able to legally make one common law. Imagine there are 30, 40, 50 travel committees. How will you have one common law? That is called codifying. When you codify something, you give it a legal shape, legal provisions, make a law, statute out of it. That has not happened. Then corruption in ADCs. I mean, corruption, of course, is a standard issue in our country. Some of you here will realize it very shortly once you join the service. Some of you will be corrupt, others will have to face the challenge of corruption within their office only. You have to decide which category you belong to. Then, irregular financial devolution. The money which is sent by the center or states is not regular. There is always going to be irregularity in the release of funds. That is how you keep a check and control over these institutions. I mean, you will say, sir, but we have given them power to raise taxes. Come on, be serious, sir. What kind of taxes are they raising? Land revenue, you hardly have buying and selling of land. Animals, tax on animals, vehicles, entertainment, etc., very nominal. So these areas, just like panchayats, have to depend on the government for taxes. Government will make sure that you beg in front of them for a single penny. Elections round the corner, money is sent. So irregular devolution of funds happen. And then land alienation. Now you will say, how is land being alienated? We can't buy land only. Of course, you can't buy land. But there are two ways in which land is being taken away from these areas. Very interesting. One is through via lease. So land is not purchased, it is taken on lease. 99-year lease. 499 years lease. 499 years of lease. That is as good as purchasing land only. You have taken land on lease, on rent for 499 years. I mean, for 8 generations. So that is as good as purchasing. Secondly, also via Benami. What is Benami? Benami means when you purchase property in somebody else's name. So let's say you have the money, you purchase property in the name of some scheduled tribe in the area, who may be a worker in your field, in your worker in your house, etc. So he is the legal owner, but you are the real owner. So a lot of bureaucrats used to invest money like this only, Benami property. Okay. As I said, that tribals of these areas are not people who are illiterate or not aware of the realities. They know everything. Okay, they are educated people. So this kind of nonsense will not work with them. That is why, because of this, you see a rise in tribal non-tribal dispute. The result: increase in tribal non-tribal dispute. Okay. Then the issue of representation. Issue of representation. So in some states, take an example of Assam only. Example, Assam. In Assam, we have 12.4% scheduled tribes, out of which an overwhelming 35% are just one community, Bodos. Don't you think that Bodos will govern and hijack all the ADCs? And in their own ADC also, other tribal communities are hardly represented. They have no say in the ADC, right? So since they have no say in the ADC, other tribals will feel that what is the point of this Schedule 6 area and autonomy? My tribal culture, my tribal custom, my way of life, my personal laws are not being codified. This bigger tribal group is completely overpowering us. So tribal conflicts also take place because of lack of representation, because of lack of size. Democracy, numbers. If your tribal group is larger in number, simple, you will hijack everything. Lastly, the relevance of tribals, ADCs in Meghalaya. Now, in Meghalaya, barring the small part of Shillong district, almost the entire state is under ADCs. I mean, why do you have ADCs then? Or why do you have government then? Look at the map of Meghalaya. This is Meghalaya actually. This is Meghalaya. Okay. The entire state, barring a small part of Shillong district, is covered under ADCs only. Then what's the point of having ADC, or what's the point of having state government? Overlapping functions uselessly. So that's all as far as the issues concerning Schedule 6 areas are concerned. We are done with the Schedule 6 areas as well. Okay. Lastly, let us solve some questions. Firstly, solve this question. For the first time in the year 2022, a question was asked from Schedule 5 and Schedule 6 areas. For the first time in the last 20, 30 years. So I know of. In the last 3 decades, not a single question was ever asked by UPSC. So finally, a question was asked, and we know UPSC's behavior. When UPSC asks a question from a topic, they go crazy, they go overboard. Now they'll keep on asking questions for the next 3, 4 years from the same topic. Okay. Please mark the answer. A lot of you mark this correct. I don't know why others mark other kind of options. If a particular area is brought under the fifth schedule, which one of the following statements best reflects the consequence of it? This would prevent the transfer of land of tribal people to non-tribal areas. This is the right answer. This would create a local self-governing body. Really, a local self-governing body is already there for rural areas. If you bring some body under the fifth schedule, does not create the provision of panchayats. Panchayat provision is already there. Okay, so B is wrong. This would convert that area into a UT is of course nonsense. The state having such areas would be declared a special category state. Of course not. There's nothing called special category state now. Okay, special category states were there earlier, and bringing an area under fifth schedule will not bring the entire state into a special category state. Clear? Somebody says D is also correct. I'm telling D is wrong. You're saying D is also correct. What can I say to such kind of points? Anyway, this was an easy question. I'm not sure if some of you found it very difficult, because I have been saying again and again the purpose of these areas is to prevent land alienation, protecting the culture and custom. Nevertheless, this year a slightly difficult question was asked. Slightly difficult. This was a question asked in 2023. Okay. I'll give you a minute. Please mark the answer accordingly. Take a minute of time to mark the answer. Okay, a lot of you got this correct. Great. So B is right. Within a state, the notification of an area as a scheduled area takes place through an order of president is of course correct. The largest administrative unit forming the scheduled area is a district. It should be a viable administrative unit, and the lowest could be a cluster of villages in a block, which could be a gram sabha. Gram sabha is a village or a group of villages. Is correct. The CM of the concerned states are required to submit. It is not the chief minister, but the governor submits report to the president. Clear? So 3 is wrong, 2 statements are correct, only 2 is the right answer. That's it. We are done with the discussion on Schedule 5 and Schedule 6 areas as well. Okay. Now, moving on to emergencies in the Indian Constitution. Emergencies in the Indian Constitution. So, what kind of emergencies do we have in the country? There are three different types of emergencies that are there in the country. Those three emergencies are what? The national emergency, the state emergency or constitutional emergency or president's rule, and lastly, financial emergency. National emergency is referred to as the proclamation of emergency. National emergency, Article 352. President's rule, also called or state or constitutional emergency under Article 356. And finally, Article 360 is the financial emergency. Okay. So, in proclamation of emergency, we have other important articles also, like Article 353 is there, 354, 358, and 359. These two articles are very, very important. 358, 359. Then, second is the failure of constitutional machinery in the state, which is president's rule. The three articles are 355, of course 356, and then 357. This article 355 is important. Finally, we have only one article 360, that is a financial emergency. So how many times has the national emergency been proclaimed? Tell me. Let's see. 66. 1, 3, 3, never, one time, two times, six times. Three times so far. Three times. One was in 1962 Indochina War. Second was 1971 the Bangladesh Liberation War. And third by Indira Gandhi, 1975. How many times has this been imposed? President's rule. Over 100 times. In fact, 115 times till 2016. 115 times. So how many times has financial stability under threat, the financial emergency been imposed? Tell me. or let's write this, never imposed so far. Okay, this is some basic information on the emergency, starting with the very first emergency, that is the national emergency, Article 352. First up, who can impose this emergency? The president can impose this emergency on the satisfaction of the president, right? Written communication and the satisfaction of the cabinet is required. Cabinet or council of ministers? Actually, this particular change was made, added via 44th Amendment Act 1978. Okay, because Indira Gandhi imposed what? Indira Gandhi imposed emergency on her own without even consulting the other ministers. So, to keep a check on the prime minister, this this modification was made in Article 352, that the president will only impose emergency on the written communication of the cabinet. This is the only place in the entire constitution where the word cabinet is used actually. Only place in the constitution where cabinet is used. But the meaning of this word cabinet is same as council of ministers. Meaning same as council of ministers in article 74. Okay, that's it. So the president will impose it. But then the point is when? When should the president impose emergency? If the president is satisfied, if he is satisfied that grave emergency exists, or there is a threat to the security of India or a part thereof, or there is an imminent danger of war, of external aggression, or even armed rebellion. If there is a grave danger of armed rebellion, then also emergency can be imposed. Emergency can be imposed in the entire country or a small part of the country. It does not mean that we have to have national emergency in the entire country. It can be for a small part also. Clear? Now, just one more point here. Indira Gandhi in 1975 imposed emergency on the grounds of internal disturbance. What is internal disturbance? It's not defined. An internal disturbance is a term which can very easily be misused. It can very easily uh, be misused to wrongfully implement emergency, right? A classic example of this situation was the fact that Indira Gandhi's use of emergency was based on a protest going on to asking her to resign from the post of prime minister. Okay, so that is it. 10 people stand up and protest. Emergency, internal disturbance is happening. It can be used in that sense also. That is why the 1978 amendment, but done by Janata Party, which came to power, it modified the provision to now say not internal disturbance but armed rebellion will be the criteria to impose national emergency. Clear? Now, what's the role of the parliament? What role does the parliament play here? Whenever emergency has been proclaimed by the president, it should be approved by the parliament within 1 month of the proclamation. So, parliament has to approve the emergency. What kind of majority? Special majority. This is the same majority which is required to amend the constitution also. Two-third present and voting, more than 50% of the total strength of the house. Clear? Now, once the emergency has been approved, it remains in force for 6 months. Force for 6 months, 6 months from date of approval of proclamation. Are we clear? Not the date of proclamation, date of approval of proclamation. When the parliament approves the emergency continues for 6 months. Okay. Now, after 6 months, if you want to further continue emergency, again, for every further extension of 6 months at a time, parliamentary approval. What kind of approval? Same, special majority, parliamentary approval. Every time it is required. And for how long can the emergency continue like this? Can extend or continue indefinitely. But the only criteria is it is subject to approval by the parliament. And if the parliament is not in session, the moment the parliament comes to session, within 1 month. Clear? So that will not be a problem. When the parliament is not there, how can we get it approved? But the moment they come into session, within 1 month of the first date of the session, this should be approved. Okay? Now, how can the emergency end? Who can revoke it, end it, remove it, or who can change it? Emergency can change also. For example, right now emergency is in say Haryana. After 2 days, emergency is in West Bengal. After 10 days, it is in Tamil Nadu. After 5 days, it is in Manipur. It can happen. Okay, it can happen. Now, president via proclamation, via order, can remove it at any point of time. Before the end of 6 months, also, the emergency can be removed by the president, by the government, of course. However, when it comes to the parliament, parliament approves emergency. Can parliament remove emergency? Yes, they can. But only Lok Sabha. No need of Rajya Sabha. Only this is a special power of Lok Sabha. So, in the topic special powers of Lok Sabha, we had discussed this point actually. No, we had not discussed. I had said that we'll discuss this later on. The time has come now. So, what is the special power of Lok Sabha? If there is a national emergency in force, then the quorum of the Lok Sabha, quorum, 1/10 people of the Lok Sabha, they can give a notice to the speaker in writing. And if the Lok Sabha is not in session, then to the president. Once the speaker or the president is given the notice by 1/10 MPs in writing, the speaker or the president will have to call for a special sitting. MPs are informed that a special sitting has to take place within 14 days of receiving the notice. Next 14 days. Now, that special sitting will be conducted where all the MPs will come and this matter will be put to vote. Should we remove emergency? Yes or no? Ayes or noes? MPs will shout ayes. Emergency removed. Resolution should be approved by simple majority. Resolution to remove national emergency should be approved by a simple majority only. So look at the provision. To impose emergency, a special majority is required, but to remove it, it's way easier. A simple majority is sufficient. Are we clear on this, everybody? Okay, great. But we have now seen the provisions of emergency. What happens? What is a problem if emergency takes place? These are the effects of national emergency: executive effect, legislative effect, financial effect, and effects on fundamental rights. First up, executive effect. Very basic. See, when emergency is imposed, state governments are not dismissed and the assemblies are not dissolved. Everything functions exactly the same. It is just that now the states are under complete central control. Center can give any orders to the states on any kind of topic. So states come under complete control of the center. Legislative effects. Now we knew one Article 249 way back. This Article 249 said that if the Rajya Sabha approves, then there can be what? If the Rajya Sabha approves, then the parliament can make laws on stateless subjects. However, during national emergency, during national emergency, there is a constitutional provision, Article 250, which says that Parliament is empowered to make laws on matters of the state list. Okay. So during a national emergency, Parliament gets the power to make laws on state list subjects also. Clear? Now, this does not mean that states don't have the power to make laws. States also have the power to make laws on those topics in the state list. It is just that Parliament can also make laws. So you can assume or have an understanding that state list acts like what list? Concurrent list. Because now both the Parliament and the states make laws on state list subjects. Clear? But if any law is made by the Parliament on any topic which is in the state list, what happens is the law continues till the emergency continues. When the emergency is over, the law continues for 6 extra months and then becomes inoperative. Laws made become inoperative 6 months after emergency ceases to operate or emergency ends. Are we clear on this? Just like Article 249, all laws made during the 1 year period of authorization will cease to operate 6 months after the end of authorization. Here also, 6 months after the end of emergency. Then one more thing, the duration of Lok Sabha or the Vidhan Sabha, the directly elected houses, is 5 years only, right? After 5 years, they are subject to automatic dissolution. But during emergency, the parliament by law can extend, may, not mandatory, may extend life of Lok Sabha or Assembly by 1 year at a time. This happened during the Indira Gandhi's 1975 emergency. The parliament did extend the tenure of Lok Sabha twice for 1 year at a time. And the 1971 Lok Sabha functioned for almost 6 years, 5 years and 11 months. Are you clear? So, the tenure of the Lok Sabha will extend if the parliament makes a law. Finally, we have financial effects. So, very simple. Whenever there is emergency, the center state revenue distribution can be altered, can be modified. Clear? And this revenue distribution modification will continue till the end of that financial year in which the emergency ended. This revenue distribution will continue till the end of that financial year in which the emergency ceased to operate. For example, if emergency ends today, that is 13th of July, the change of revenue distribution, how much money the states get, how much money center keeps, this will continue till 31st of March 2024, end of this financial year, right? That's it with respect to the financial effects of national emergency. Let's end our discussion here only today. Tomorrow, we'll take up for discussion the financial effects of the fundamental rights effects of national emergency. We'll discuss the provisions with respect to the emergency, the president's rule, Article 355, 356, all these things. Then federalism and center state relations. Okay, that's it for today. That's it for this class. Jai Hind. And of course, the task for the day, I hope you have been covering Yojana Kurukshetra diligently. Still, I see that some people ask, where is this Yojana magazine, Kurukshetra magazine? It is disappointing to say the least. Then the PPT revision has to take place. Then it is very, very important also to focus on the monthly magazine. We are, I think, studying the month of April. Once April is over, start for the month of June. Then uh, the book Political Theory. Which chapter have we reached so far? Chapter 7 or 8? Second revision? No idea. And then read the editorials. Please finish this task. Nirbhay, I just explained this point only, that if the house is not in session, then we'll wait for the house to come to session, and then once the house comes to session, we'll get the house to approve the emergency within 1 month. Okay? Editorials need not be revised, but if you find some interesting word or phrase there, you can copy it in your notes. Sejal, if Pakistan attacks India, emergency can be proclaimed. Article 365, I'll discuss it. Don't worry. Don't panic. Why is 365 not mentioned? Because 365 is not under emergency provisions. That is why it is not mentioned. Don't worry on this, right? You have just started learning. I've been teaching for a long period of time. So it's okay. Don't panic. We'll discuss that. Can the speaker or president decline the resolution? No, they cannot decline the resolution. Who gives advice? See, it is Council of Ministers which gives the advice. Gaurav, because it did not really amount to a huge war. That is why. Prabhakaran, legislature party, this has been explained in the class, live class. Legislature party refers to those people from the party who are legislators. Okay, so BJP has 10 crore party workers. Those 10 crore people are called political party BJP. But from BJP, certain MPs are certain members of BJP are MPs, MLAs, MLCs. Though that group is called the legislature party. Megha, that I have no understanding of because it was done by an amendment later on, so it could have been a wrong choice of words also. Muhammad, either is good, though I would suggest Indian Express, but both of them are equally good. No difference whatsoever. Divya, what about Yojana Kurukshetra? What about that? You tell me. Anything special about that? What kind of question is? Half a question. Mangala, I think the focus should be on reading, not such things. We tend to get involved in these things only. A lot can be said about the kind of questions people ask on the way they are aligned in their preparation. Uh, Editorials from where to read? Newspaper. Why do we ask these? I mean, has it not been said clearly? Gist of Yojana Kurukshetra separately is a comprehensive gist. I would prefer you read that comprehensive gist. Vivek, sir, what are you asking, sir? Let's wait for tomorrow when we have a discussion of financial emergency. Then we'll discuss that. What is the excitement of financial emergency? No, Kaustubh, those two areas are being treated differently because of the people living in different conditions. Srimant, that could be done. In fact, some of you I know for sure are busy sleeping. That is how the reality is also. 10 lakh people appear for the fill up the form. 5 lakh go for the exam. Most of them don't score more than 30, 40 marks. So you are not preparing seriously. Don't worry. Some of them are preparing seriously here only. Others are not. It's okay. No, Kumar, editorials are sufficient. Newspaper reading would take too much of time. Rather, focus on mugging up the monthly magazine. That would be okay. 6, 7 marks out of 10. That's a very decent number. When there is, if you want to know whether somebody is a scheduled tribe or not, please download Constitution Scheduled Tribes Order. It's a PDF of 1950 document. Download it and read to your heart's content. Find out which people are STs and SCs. Lockdowns, etc. There are various provisions, Disaster Management Act, Epidemic Diseases Act. Those were used. For curfews, we have CRPC, IPC, CRPC, unlawful assembly, right? Emergency was not proclaimed. Okay, others can leave. Oh, I am not showing the leaderboard. Why? See the leaderboard. Enjoy it. As if there's some hidden agenda. Janvi Sat. Who is Sat? What's your name, Sat? Please clarify. And Hilo are at the top. And then Kirtana, Surya, Lucky, Pratik, Abhinav, Shali at number 4. Then others at number 10. We have some Elon Musk also. Okay, Megha, satisfied after seeing the leaderboard? How much marks we get in mains question? Your target is to roughly get around 50-60% marks. That would be very good marks. Okay, whether to do or not, what to do or not, Shrimant. Yes, we can. You can make notes. I mean, you can do one more thing. What you can do is take a printout of these PPTs only, white background printout that you have, and write in the class. Aji Nisarg, what's the problem? Second point. The state list subjects are now open for center also. States are already making laws. Center can also make laws. Okay, on the state list subjects. That's it for today. We are done with the discussion for today, and let's meet tomorrow. Please mug up all the points, study properly, revise properly, and revise your monthly magazine, Yojana Kurukshetra, political theory, and the PPTs at least 3 times. That should be all. Let's meet tomorrow. Till then, that's all for me, guys. Jai Hind.